Hello, welcome to ABLA's latest in its series of workplace webcasts. My name's Julian Arndt. I'm very, very lucky, very, very privileged to have with me ABLA's resident expert in workplace investigations. He's been a lawyer at ABLA for many years, has been a lawyer for many years. He's worked in house-done investigations. He's also, for a number of years, operated his own workplace investigations business. If experts make things simple, today will be a very simple event. Ed Austin Woods, welcome.
Thank you, Julian. Absolute pleasure to be here.
So we're talking about workplace investigations, Ed, a practical guide. What are we going to speak about today?
So the overview, Julian, is, so we'll look at the fundamentals, the what of investigations and why we investigate, the legal framework that surrounds and underpins investigations, when to investigate, and when we do that, types of investigations, whether informal investigations or formal investigations, who should actually conduct the investigation?
That's a good question.
Do the investigation.
Yes.
How to plan the investigation, the steps necessary in the investigation to go through, how you go about collecting the evidence, analysing the evidence, and ultimately reaching findings and writing the report.
So there's a ridiculous amount of content in that, Ed. Today is in an hour. We probably will do our best to pack as much as we possibly can in.
Yeah.
We might give a bit of an ad at the end of our presentation for some training that ABLA does, but certainly, hopefully, we can pack as much as we can in. We're going to lean on Ed to give us some hints and tips. Hopefully, we've got some interesting opinions about investigations, and let's get into it.
Great. Sounds good.
So the fundamentals, what and why. The golden rule, the reason why you conduct an investigation, the reason why investigations are a thing in workplaces is to find out what happened, to determine what occurred.
Yeah.
There are all kinds of good reasons to do investigations that to do with risk mitigation and protecting positions and all kinds of other things. But ultimately, what an investigator is doing, Ed, is finding out what happened. That's the case, right?
Yeah, exactly. It's often investigations, Julian. Be aware there are disputed facts as to what's happened. And as you said, we just need to find out what's actually occurred.
So let's start off with the golden rules. The first one is the no bias rule. The investigator cannot have a preconceived opinion. Now, you've done more investigations than I've had hot dinners, Ed. What do you say to this? Isn't this obvious? Like, isn't this easy? Doesn't it?
It is a very obvious statement, but in practice it can be difficult at times, because I think as human beings we all have preconceived opinions on lots of different things. So I think as long as we're conscious of that and we try and put that to the side as much as possible, it's really important to ensure that all of the participants, particularly the complainant and the respondent, have a proper and transparent process, and it's all done in a procedurally fair manner.
I always think of it as quite liberating, the fact that if you are tasked with doing an investigation, you can sort of shed the fact that you're employed by a particular employer, or you're being paid by a particular employer to do an investigation, or maybe as a lawyer you've been instructed to do an investigation. You have to leave all that behind. You're not on anyone's team. You're not trying to achieve any particular results. You're just trying to find out what happened, which is the fundamental purpose. So procedural fairness rule, which is golden rule number 2, you must provide relevant information to the accused to allow people to tell their side of the story. This is the building block for how you would go about not only writing a report, but just setting up the whole process, isn't it, Ed?
Yeah, absolutely. So obviously a respondent needs to be provided with the relevant material to allow them to sufficiently put their side of the story. We got
a lot of questions, and I should say that I'll be looking at the questions on the iPad as they came in, but we always get heaps of questions about, well, what do you actually need to put to the respondent? What do you need to tell them? My layman sort of simple phrasing of the principle is, if you're going to rely on it in your report, if it matters, you've got to get what the respondent says about it. Otherwise, if it does get to court or a tribunal at some later stage, it will be a big problem, the fact that the respondent never got to give their alibi or give their excuse or give their mitigating circumstance or say it wasn't me or whatever they needed to say. So that's fundamental. The third golden rule is the documentation rule: create a paper trail that can be relied upon. This is, it's more just good practice, but I must say I'm often disappointed, particularly as an external lawyer, when I look at internal investigations done by organisations, that all of the effort and all the goodwill and all of the stress that the investigator has taken on hasn't quite been translated into, proof, letters that were sent, investigation reports. And Ed, do you have a take on the documentation rule?
Oh, I think it's critical. It's critical, particularly when there's a potential of disciplinary action up to, obviously, including termination moving forwards. You need that paper trail, that documentation, to rely on to support why potentially you're taking that action.
So long as you're not doing anything unlawful, there's nothing wrong with putting it down in paper.
Absolutely.
But, I think the idea that it's safer not to say anything or not to put it in writing, that doesn't apply in investigations. The last golden rule, the question of external perception: what will a decision like this look like in the legal decision or in the media? I call this the Tasmanian wicketkeeper rule. You have to think about, when you're doing an investigation, or maybe deciding whether you are not going to do an investigation, how is this going to look? What is going to happen if we do nothing? Now, maybe you're in an organisation that isn't particularly prominent in the media. You never know what will reach the media. But everyone can have a Fair Work Commission case brought against them. And Ed, I know you and I love reading a Workplace Express article that come out, and it's inevitable that an article will pick up the fact that the commission or a court will give, whether it's the internal HR person or whoever the investigator was, if there's some deficiency in the report or in the process, the media will give, and the judgments will usually give a little kick to the investigator to say, why didn't you do it? I can't believe an organisation like this couldn't do it properly. And as an investigator for many years, Ed, you must have lived in fear of that constantly.
I'm very thankful that never happened to me, but it's always at the back of your mind, because that's the last thing that you want to happen.
Yep.
Yeah, in terms of your reputation and the reputation of the business potentially representing.
Now, that shouldn't, and I should just make this clear, that shouldn't compromise the no bias rule. Yeah. It shouldn't compromise the fact that the purpose of all of this is to determine what occurred. Just because the media or a court might have a different view doesn't mean that you should change the story. Yeah. But you need to keep it in mind.
Yeah.
And if you need help, get advice.
Absolutely.
So if they're the rules, and if that's the purpose, why would you conduct investigations? Why would you try and find out what has happened? Ed, do you want to take us through some of those dot points, and maybe we can discuss some of the interplay between?
Sure, Julian. So there's a number of reasons. First reason is that an employer has a duty of care over its employees. It also has work health and safety obligations to ensure, as far as reasonably practicable, a safe workplace. So if a complaint is raised, such as allegations of bullying or sexual harassment, the employer needs to respond appropriately, and that would be by...
Well, they need to find out what happened.
Exactly.
Is this a risk? And if you don't, again, how's it going to look if you do nothing? If someone complains, you do nothing, you don't find out about it, and then something, the risk manifests, someone does get injured, that's a big problem. That's right. You can also use investigations to resolve workplace conflict, Ed. This is your speciality. Going into a really sticky situation between two employees, long-running feud, 10 years of bad blood, lots of conspiracies between one another, claims, counterclaims, and you ship it off to Ed, and he goes in to try and find out what is happening, try and find out whether any misconduct's occurring, whether there's a risk, and to unpack what can be really messy into office relationships and interplay. In the same way, if you get a grievance or a complaint, you might conduct a workplace investigation. they're the sort of reactive reasons you might conduct a workplace investigation. One of the big things we see and we do is where there is an allegation or a sense that someone is that misconduct has occurred. Before the employer takes action, the employer will want a sound basis to proceed, and that sound basis is, well, we got it investigated, and it is correct, it is factual that this is occurring or that occurred. So that's pretty basic, and everyone on the webcast today or watching it on YouTube at a later date will know and be familiar with that.
Sure.
Workplace culture and engagement, and I just put in brackets confidence. I'm accused often of making these slides slightly random or hard to understand. I mean, I've put that in there because I think an employer and an organisation who takes grievances, who takes employee feedback seriously and actually puts resources into investigating those grievances inspires a confidence in the organisation that is absent if you just put things under the carpet.
That's right. The employees will be engaged. They'll have the confidence, and they will know that if things are genuinely troubling them, that the organisation will do something about it, or will at least look into it and treat their concerns seriously.
Particularly if you engage maybe an external investigator or someone of a senior level or do the investigation properly, an employee will not be in a position where it says, well, I've just been ignored here. Yeah. I've just been pushed to one side. This has gone under the carpet. Right. It's really important, and it can have much larger effects than just that employee. So it's a good thing to remember. The legal framework of why you might conduct a investigation is on this slide, and I think the purpose of putting all of these sources of law here, Ed, is that in order to mitigate risk, very often an investigation will be done. These are just a range, and it's probably not exhaustive, but these are the types of legal issues, legal avenues, legal areas that you might find yourself using an investigation to mitigate some risk. Now, let's start at the top, unfair dismissal. What does investigations have to do with unfair dismissal, Ed?
Well, I suppose the reason that you're dismissing someone, so that valid reason. So it could be misconduct, and it can obviously even be performance.
And I guess let's say you told about a certain set of circumstances and you think, well, that warrants dismissal. You dismiss without a proper investigation. What can happen, and often does, is that in the unfair dismissal case, you found out that there was no valid reason to terminate, or there was a reasonable excuse as to why that person engaged in that behaviour. You've got a fair degree of legal risk at that point. If you'd done the investigation, worked out that you had a sound basis to proceed, crossed the T's, dotted your I's, you're in a much better place. For general protections, it's a similar story, although general protections is particularly useful because the general protections jurisdiction is about why you did a certain thing, and you want to avoid the allegation that you did it for an unlawful reason. If you have an investigation which makes out a finding that someone's done the wrong thing, you can rely on that finding, and that will be gold in any general protections case. The other sources of law on this slide are, I guess investigations relate to them in different ways, but I think in preparing for this presentation, Edo, we talked about the importance of investigations for anti-bullying and discrimination claims. Do you want to speak to that for a couple of moments?
Yeah, sure. So obviously the Fair Work Commission has an anti-bullying jurisdiction. For bullying complaints made, the Commission and other judicial and regulatory bodies have a reasonable expectation that the employer will have properly investigated and looked into an allegation of bullying.
It's the first question they ask, invariably, if there's a bullying claim. Has this been investigated? What did the investigator say about it? And if you haven't done it, it's not going to be good.
No.
Equally in discrimination, that can be very difficult to independently assess and then just simply ignore or dismiss. If someone makes a claim to say I'm being discriminated against in my employment, it is not going to be good enough for the person who gets that complaint to make their own decision and say, that's not true. Just, too bad, so sad. It really is something that needs to be supported by a view of an investigator undertaking a proper process. Whistleblowing's up there, and I think whistleblowing is probably only relevant to some of those who are listening or watching today, but that's a whole different world, isn't it, Ed, where it's a very highly regulated part of an investigator's, I guess, world and framework. And if you have a whistleblower complaint and something that is put as a whistleblower complaint, I think you need advice. Yeah. I think you really should be getting advice because it is very technical and it is not something that can be done without proper regard to those technical requirements. Yeah. The great question is, do we need to investigate this?
Yeah.
And what do we need to do? We got 30 questions asking about what types of things you need to investigate.
Yeah, it's a good question.
And how to investigate. And in some respects, the questions when to investigate and the types of investigation are related because for some things, you might not investigate at all. And for other things, you would investigate, but maybe not go the whole hog, the full form investigation. So let's dive into that now. Ed.
Yeah, so I suppose a lot of it comes down to the seriousness and the gravity of the allegations and also the potential consequences that can arise if those allegations are substantiated. I suppose there's two different ways you can do an investigation. One is an informal investigation and the other is a formal. So an informal investigation, the type of things you'd be looking at is just general rumours and gossip in the workplace. We might not get on with someone personally, generally minor or less serious matters.
And the consequences are therefore going to be less serious. Right. So you can probably, I don't want to say take the risk, but you can probably, it makes sense to approach it in a slightly less formal, less expensive, less time-consuming way.
When you say informal, what do you mean by informal?
So, I think that the hallmarks of an informal investigation would be, it would be more likely that you would have conversations with people that aren't set up necessarily as a interview witness scenario. You would always take notes of whatever you do, whether it's informal or formal, because that's one of our golden rules, Ed. Get the paper trail. Whatever you're doing, get a paper trail. But I think the less formal investigation, the less likely our full form investigation report is going to be put, less likely formal letters are going to be sent out. And you don't want to get that call wrong, because I think doing an informal investigation for something that warrants something serious is, one, opening you up to making the wrong decision because you haven't done it properly. Two, opening you up to a claim that you haven't afforded procedural fairness to the respondent. If you conduct an informal investigation and decide, actually, this is pretty serious, and I think we should terminate this employee. If you haven't gotten all the responses that you need, if you haven't got a paper trail, you're running a risk if they bring an unfair dismissal claim or something else. And the last thing it does is the less formal the investigation, the more likely it is that you're going to get a kick in a judgment from the Fair Work Commission or from the court or from the media or wherever. Yeah. So that's the risk that you run. Formal investigations are expensive and they're time consuming. And never forget the toll that formal investigations, or really any investigations, takes on everyone, not just the respondent, but the witnesses, the accused. It's not particularly productive, a period of investigation. So this is something you need to weigh up. And as you say, Ed, investigations, this is not an exact science. There's a bit of an art form to all of this. You have to make some judgment calls through it. And no investigation is ever the same, is it?
And could you start off with, Julian, do you think an informal investigation, and as you're moving through that, you understand that it might be a little bit more serious than you initially thought, and then move to a process?
Absolutely, you could. There is always time in investigations. There's always time to do things properly.
Yeah.
And my view is that if you're thinking, well, that's very inconvenient that all of these serious allegations have come out in the informal process, inconvenient or not, both you and I have had to many a time write to our instructors when we're investigating something and say, look, you need to understand the scope of the investigation that you've given us or given me has broadened. There are other things at play here, and we need to change tact, either to make it more serious or maybe to introduce a counterclaim or whatever that may be.
And invariably happens as well, doesn't it?
Like clockwork.
Yeah.
I think we've covered this slide basically, Ed, both in terms of when to investigate and why you might investigate. So why don't we proceed forward? I should just note on that first point, particularly where the context is sensitive, if allegations are made against the executive, for example, I don't want to be the person sitting in HR thinking to myself, oh, I'll just ignore that. I just won't look into it. In the same way, I wouldn't necessarily want to be investigating my own executive.
No.
I mean, we'll talk about who should investigate and when. But where the context is sensitive, where you think, well, this could look bad, or more to the point, this could be bad, get an investigator, getting it done properly, and buy the security of having it investigated. Here are some traditional reasons for investigating misconduct and serious misconduct. I mean, particularly where it's going to result in an unfair dismissal risk, you want an investigation to rely on if you have to go to trial. To actually work out whether there's a breach of policies or procedures, you need to work out what happened. Sometimes it's not clear. Safety is really important. Fearless leader Nigel Ward, obsessed with safety, as all good leaders should be. If you don't investigate safety incidents, you're not taking safety seriously. And then finally, and we've touched on this already, complaints about bullying, discrimination, harassment, victimisations are very difficult to just deal with on the face. You have to go into it. And as it says there, it's a non-exhaustive list. Who should investigate?
Yeah, so I think the first bullet point there is particularly instructive. The investigator needs to be impartial, first of all. So, and as the second bullet point points out, you can either do an internal investigation or you can have someone externally doing it. But it comes down to those 2 points, impartiality and competence. So internally, if an HR department is considering doing the investigation, obviously whoever's doing the investigation shouldn't have a close relationship with the complainant, the respondent, or really any of the witnesses.
Because then they're not impartial.
That's exactly right.
In the same way, if you're doing it internally, you need to have someone sufficiently experienced, sufficiently trained, sufficiently confident to go and do this. And that's the competence point, because HR practitioners have a lot going on, and an investigation, as you know, Ed, can be all-consuming. If you're speaking to multiple witnesses, writing large reports, all these kind of things, this is a huge, in some cases, a huge investment of time that occasionally HR practitioners do not have. And so having the impartiality and having the competence to do it, you also need the time. I guess the two middle points can be summarised into one. The more serious it is, the more complex it is, the more sensitive it is, the less likely I think it can be done in-house by people without human resources or investigations training skills. Certainly some investigations can be done by non-HR practitioners, by managers, ops managers and so forth. Some are just too complex, they're too sensitive, they're too serious, and it needs to land in the hands of an expert. In terms of resources, I've put in italics speed. Investigations they're time critical, aren't they, Ed?
Yeah, they need to be done in a timely manner.
Why is that?
as you said earlier, for all participants in an investigation, it's not a nice experience to be going through. It's very challenging on professionally and personally as well. So obviously you want to do it as expeditiously as possible. And there might also be someone that's been stood down from work and they're sitting at home. And I think there's a reasonable expectation from employees and the courts and tribunals that it's done in as timely a manner as possible. But in saying that, as you'd be aware, they can take quite a bit of time to do properly and appropriately.
That's right. I mean, I think from our perspective, as lawyers who are regularly instructed to do these things, sometimes they can take, because witnesses aren't available, people are on holiday, or witnesses are ill or injured. But when you can work on them, you are working on them at 100%. You are working on them full bore to try and get it done as quickly as possible. As I said before, HR practitioners have a lot going on. If you don't have the bandwidth to devote to this, you need to think carefully before you become the investigator. The last point there, legal professional privilege. I don't want to labour the point because it's slightly self-serving, but obviously an investigator who is a legal practitioner can afford the benefit to their instructor of legal professional privilege. It means that, Ed, why don't you've operated under the cover of legal professional privilege for many, many years. Why don't you explain some of the benefits for someone?
Sure. I suppose if it's a sensitive investigation or are there serious allegations, the client may wish to attempt to claim privilege so that the report and the contents of the investigation aren't used later in things like court proceedings.
Yeah, and obviously it gives you the option. You can publicise the report, you can publicise certain things, but it gives you the option to say, actually, no. Sometimes, very often, the investigation might come out with a result or come out with findings that you think, oh my goodness, we never want to let this, we don't want this aired as our dirty laundry. Legal professional privilege allows you the benefit of that in some circumstances, and it's something to think about, particularly for sensitive matters. Just before we go on, did you ever have a trench coat when you were an investigator?
I did not.
The hat?
No, I didn't have the hat either.
It's a shame. We're planning the investigation now, Ed. There's 4 columns here. We're going to go through each column, and we probably don't have the time to go through these in the fullness that they may deserve. But let's go into what's called the triage process.
Yeah, I think it's all relatively straightforward, but it's helpful to work through it. So obviously, if a complaint's been raised, or complaint's been filed, you need to assess it, understand what the nature of the complaint is, what the allegations are, understand, again, who's going to be conducting the investigation, the type of process, whether it's going to be an informal process, whether it requires a formal process, the policy framework that maybe underpins some of the allegations, such as codes of conduct, bullying policy, sexual harassment policy.
This is really important because people can't just say, oh, well, they've done the wrong thing. Speaking of questions the Commission asks, the first question that a commission member will ask in an unfair dismissal is, this behaviour that you say the applicant did, where did it say that he wasn't, or he or she wasn't allowed to do it? Where's the policy? And you need that policy to know what you're investigating. It also helps to know that the employee's been trained in that policy. Otherwise, that can cause another different problem. Yeah. Immediate steps and suspension is always a bit of a fraught subject because it's quite common, isn't it, Ed, that an employee who is the subject of investigation, a respondent, might be stood down. Usually, when I say usually, that's probably understating it, almost in all cases, stood down with pay while the investigation goes on. It's a good reason for doing an investigation as quickly as possible so you don't have to continue to pay the person. But you need to make a call whether it's appropriate to suspend that person. What are some factors you might think about in making that decision?
Sure. So it would be the relationship between the complainant and the respondent, such as if the respondent was the person's direct manager.
Yep, so there might be a risk there that them being in the same workplace in an ongoing way, if the allegations are true, might be a problem that you want to fix by sending them home. Pandemic is great for this. Pandemic is not good for anything, but removing problem scenarios of people in the workplace, it's really helpful because you don't have to necessarily suspend someone, send them home with nothing to do with it. A lot of people are remote working, so that's helpful.
I think even when people are on site, there are obviously alternatives to suspension to consider as well, whether the respondent or the complainant can be moved to a different area of the workplace to ensure that they can do their work safely and that they're comfortable.
Mandatory reporting is the last dot point. This is probably extremely serious or in very sort of regulated industries, whether it be childcare or aged care or something like that. But you would not want to get to the end of an investigation and realise, oh, we were meant to tell the authority or we were meant to tell whatever organisation is required. So that's something that you should be well aware of if you're in an industry, but it's good to keep that in mind. You need to determine roles, and we've kind of spoken about this, about who's going to investigate. But obviously the investigation report gets written, and then someone has to make a decision as to what to do. Mm-hmm. It's very often not the investigator. Usually it's someone higher up. Is that the case?
Yeah, it's a really good point, Julian. And I'd always, I think, recommend that the investigator and the decision maker are two different people.
Yep.
That the investigator's not making the decision. The decision maker should be someone separate and who will review what the investigator's done, has gone through the evidence, has looked at the findings and be satisfied with what the investigation.
Can I put a word of warning here? It's very, very tempting for investigators to provide recommendations as to what they think should happen. Yeah. I think this person should be dismissed. I think this person should be cleared. I think the complainant should be dismissed. Unless you've been asked to make a recommendation, do not give a recommendation. And for the most part, there's some specific exceptions. For the most part, it is much better if the investigator is just fact-finding and they're not recommending anything. And the reason why I'm saying this in such a dramatic way is that if you recommend something as an investigator where you weren't asked to give a recommendation, that will stick out like the proverbial sore thumb in that investigation report for the rest of time. And so when the decision maker has to make their decision, if they go against it, they're doomed. If it ever comes out that they went against the investigator report, if they want to make a different decision, they will not thank you for providing a recommendation that is that they didn't ask for, because it does compromise ultimately the decision maker. The clue's in the title. The decision maker makes the decision, and so that's the person who should be making it. Yeah. It shouldn't be difficult to identify the parties in terms of complainants and respondent, but obviously, Ed, one of the first things you do in scoping an investigation is work out, well, how many people are going to actually have to talk to, how many witnesses, and you might not necessarily know, would you, Ed, at the very start?
No,
the scope.
Often not.
Where would you start? Where would you get your leads as an investigator?
I think I always will interview the complainant.
Yep.
To begin with, often what's in a complaint isn't the full scope of the allegations in any event. Sometimes there's multiple complainants.
Yep.
Sometimes there's multiple respondents. So I think that's always the first place that you'd start, is interviewing the complainant to get the particulars of their allegations.
And again, to hit on a point we hit before, it's never too late. If late in the day someone drops a name that you think, oh, I didn't know they were involved, maybe they can help, it is not too late to change the play, to put them on a list of witnesses. And if they provide more information that, again, you need to put to the respondent, that's what you should do. Yep. Initial info gathering, and we'll breeze through this quite quickly, but I think the reason why I think this is important in planning is investigations aren't purely what witnesses tell you in a dark room as you grill them for hour upon hour. I'm joking, of course. There's heaps of stuff that can be relevant to making a decision about what happened. GPS data, documents, policies, emails, medical evidence. Think laterally about how you're going to work out what happened beyond just talking to people and hearing what they say. Yeah. And sometimes, particularly on a he said, she said, which is the the classic, and there's at least three or four questions about the he said, she said, both before today and in the list so far. The he said, she said, sometimes you make your decision based on these external factors.
That's right.
In planning the investigation, obviously, you have to work out the timing and process. We'll talk a bit more about statements, transcripts, audio recording shortly, but I think trying to get things done properly as efficiently as possible is the important thing, and keeping people in the loop, Ed.
Yeah.
You would be, as an investigator, quite keen to make sure the respondent knows what's happening, where it's up to, so they're not sitting there waiting for months on end. You'd be quite keen to keep in contact with the complainant to say, look, this is, I've received your complaint, I'm planning to meet with you here, or this is when I'm going to do. And it's part of it's communicating, but part of it's a paper trail too.
Just managing the process.
That's right. Yeah. So the investigation steps, here's 11 points. And again, we could spend, and we will spend, hopefully for some of you, some days later in the year going through these steps in a really comprehensive and excellent training course that we offer. But why don't we just run through relatively briefly the investigation steps as a framework? And you love talking about the framework. You always tell me, as long as you get the framework right, Jules, everything will be fine. Let's talk about the investigation steps.
Thanks. So as we've discussed, it's always a good idea, I think, to have a plan.
Yep.
Initially, to understand, set out the process and how you're going to conduct the investigation, understand what the actual complaint is, and get the particulars from the complainant of the allegations. So really importantly, just notify everyone, simple step,
yep,
that an investigation's commenced. This will be the process that will be undertaken. And importantly, with that notification letter, you'd also be outlining obligations in relation to maintaining confidentiality.
They're the rules, right? The rules.
Yeah.
Yeah. Don't victimise someone for making a complaint. This is confidential, not to be spoken about.
Yeah.
If in terms of speaking to the respondent, that's when you would communicate whether they're being asked to not perform work, to stay out of the office on pay while the investigation proceeds. You might give them some sense of timing, or maybe just always good to know the next step. If for the respondent, the next step is that they're going to get a full set of allegations against them, it'd be good to sort of tell them that that's coming. I've got some questions on the screen talking about how much do we need to say about the incident to the respondent, or how much do we need?
That's a really good point. It was something I was actually about to say.
Please go for it.
Because obviously at the initial stages of the investigation, and particularly before you've interviewed the complainant, it's very difficult to understand the full nature of the complaint.
Yep.
So when we write to the respondent, we broadly let them know what the allegations consider. It might be sexual harassment or bullying, but then inform them that the particulars will be provided to them in due course, and they'll have every opportunity to respond to that.
Yep. Yeah. And then obviously, eventually, once you've got the particulars, giving them those particulars, and we already covered this at the start, you need to give them enough. Mm-hmm. You need to give them everything that you're going to rely on, for sure. You need to give them everything important to the decision so that they can have their say on that. The peripheral stuff, the stuff that's not going to matter, the stuff that doesn't turn it either way, perhaps you don't need to give them that. You certainly don't, in every case, and probably in rare cases, need to give them the physical complaint. Like, you're not forwarding the email from the complainant to them.
And a respondent will often ask for that.
They will often ask for that. They'll often ask for the investigation reports. They'll often ask for witness statements. Generally speaking, you don't have to give any of those things. What you need to do is give them procedural fairness. Why don't we... I just want to hit a couple of points, and then I want to keep cracking on this. The follow-ups, if necessary, asterisk, look for the counterclaim. As we discussed before, it's very, very common that a respondent, in answering an allegation or a series of allegations, will make their own allegation. The complainant says, I was bullying them. Well, actually, they were bullying me. Or the reason why it's doing this, because of something that's happened to me. You need to be quite flexible in terms of the investigation process to realise you are going to need to look into those types of things. It isn't a binary process where you can say, oh, this isn't my job, I'm not doing it. I wouldn't be just going off on a whim and conducting your own new investigations. You need to make sure that your instructor is informed and is telling you to do what you need to do. But don't be worried that things might develop and change over the course, because they often do. They always do. Collecting the evidence, we've covered this. There's plenty. There's plenty that you can do apart from just interviews with witnesses. Some questions over the course of the week about interviews with witnesses in a pandemic. I mean, I think for my part, like any process, and as you say, Ed, always set out the framework. Framework's broadly the same. Implement a standard set of rules. So try and make it consistent. If you're fine with video conferencing for one person, it would be odd if you forced people to come in for a face-to-face. As a general rule, face-to-face is always better. You're going to get better evidence out of a face-to-face. Video is slightly worse, and a phone is worse than that, and then email correspondence is worse than that. I want to touch on the methods of recording really briefly. Everyone has their own style, and you've got to, as an investigator, I think you've got to try and play to your own strengths and style. I prefer, wherever possible, to get a transcript of my interviews.
So do I.
So do I. The reason that is, Ed, is because you can't argue with the transcript.
No, and as long as you get the participants' consent and they're okay with it. And I always let the participant know. I'll send them a copy of the transcript, and if they need to clarify anything or add anything, they're more than welcome to do it. But I find it a lot more efficient than, let's say, taking a statement.
So we've got a few questions about taking of statements. Taking of statements are clearly not always necessary. I think they can be counterproductive in terms of people can really protect their positions. They can get, obviously they're going to get it reviewed by someone, possibly a legal representative. That's not a particularly good way of getting good evidence from people. You can't ask follow-up questions to a statement, so on and so forth. Sometimes it's useful to do, because once you prepare a statement and once they sign a statement, that's their word. It's locked in, and it's very difficult for them to change their view later down the track. It's kind of a good statement is gold, because you can't, I'm saying that you can't argue with the transcript. You really can't argue with the statement, because they've considered it. Informal notes, maybe in an informal investigation might be useful, but generally speaking, you want a decent record of these things. And informal notes about how you perceive what they were saying is not going to be good enough in many contexts.
And they can be challenged, particularly when there are serious allegations on foot.
Absolutely. He ain't heavy. He's my brother. Ed doesn't even smile for this. So Ed loves support people. We love support people because almost 50% of the panicked calls we get in our jobs in an investigation from investigators are usually about some standoff between an employee rocking out with a support person and the employer or organisation saying they are not entitled to this person, or the support person's acting up, or there's a problem. This is massively overblown. Do you want to spend 5 minutes there just talking about what support persons are, what are their legal relevance, and what's some common problems?
So in this type of process, because it's not a disciplinary process, there's no positive obligation on an employer to either offer a support person to a participant. That only arises in disciplinary.
Yeah, well, I mean, I think it would, if you had an unfair dismissal, it would be relevant if you refused unreasonably to provide a support person or allow a support person, or maybe you've negotiated a policy that says you get a support person. You got to comply with your policies. But you're right, Ed. There's not an overwhelming rule that everyone gets a support person at all times. But why would you? I
think it's just good practice because, as we've discussed, it's a very challenging process for everyone involved to go through. The support person's there, and importantly, to provide emotional support to the participant. So they're not there as a representative. They're not there to speak on the employee's behalf. However, in saying that, often a respondent will have a lawyer representing them or a union official representing them in this type of process. We always advise to give a bit of flexibility there, and to allow the lawyer and the union official to be present in the interview. However, to make it very clear that the employee needs to respond directly. However, at any point, the employee is more than welcome to step outside with the representative / support person, confer, come back into the interview, and then proceed with the answer to the relevant question.
I mean, we're trying to find out what happened.
Yeah.
So yelling at a lawyer or a union official saying, you're just a support person, I don't want to hear from you, hold the tissues and don't say anything, is not helping anyone do anything. I think we need to be flexible in our approach. But as Ed said, the ultimate thing is you need to get what the employee thinks, what their position is about whatever you're asking them about. You don't want to hear from the lawyer or what the lawyer has to say. You don't want to necessarily hear the union's position or what the union has to say. You want to find out what happened or what they think or what the employer should be consider from their perspective. So I think there is a level of caution and I guess anxiety around support people, which is probably overblown. In saying that, the wrong support person can be really unhelpful and can be really frustrating. And I'm sure you've been in many cases, Ed, where the support person's presence in the room is derailing the process of information sharing rather than anything else. You just got to try and manage it.
Yeah, that's right.
Analysing the evidence. So we've blown through this, but we've spoken to everyone. We've gone through all of our external evidence. We've got CCTV footage, hoping that you've complied with all workplace surveillance requirements, depending on what jurisdiction you are. You've looked through emails. You've spoken to everyone. You've got everything. What burden of proof are you applying, Ed?
So yeah, it's the balance of probabilities. Is it more probable than not that the conduct alleged occurred?
That's not the criminal law.
No.
Which is beyond a reasonable doubt.
That's right. It's a lot less. It's a lower standard.
Yep.
However, we've put up there, and without going into it in too much depth, the Brigginshaw standard. But essentially, the Brigginshaw standard means that the more serious the allegations and the more grave the consequences, potential disciplinary consequences flowing on from that, the more satisfied you need to be as an investigator that what has been alleged has occurred. So it's not so much a matter of 51-49, but with quite serious allegations, you need to be reasonably satisfied.
Yeah, and I think, the layman's way of putting it is if you're going to terminate someone's employment, you need a decent case to do so. It's not going to be enough to say, well, yeah, it is 51%. I'm probably, I think let's get rid of them. It's not how it works. You're going to need to have some level of evidence that establishes what you say happened. When we talk about evidence, though, Ed, it's not just about hard, what someone said, what was on the camera, what was in the email. There's many other things that go on because obviously some people don't tell exactly the truth in a witness statement. Sometimes things are not quite as they've been put. Demeanour, credibility, these are important things to consider as an investigator in writing your report, aren't they?
Absolutely, how someone presents themselves, whether they're contradicting themselves, it's all to be taken into account. Though I do think sometimes you do need to exercise a little bit of caution, particularly around the demeanour, because people will present in different ways. However, if you think it's sufficiently serious that maybe it will tilt the balance and the weight of the evidence, it should definitely come into account and as a factor.
That's a really good point about exercising some degree of caution in terms of playing psychologist as the investigator, because you may well be a psychologist and you may well have the requisite background and qualifications to be making assessments on people's demeanour. But for most of us, and particularly the more HR legally minded people who are conducting investigations, hopefully that group has a relatively high EQ and knows how to relate to people, can sense and has a human sense of people. But you don't want to you don't want to go too professor in terms of analysing your witnesses or going out on a limb, because the further you go out on the limb, the more likely it's going to snap.
That's right.
I should say, though, just in analysing the evidence, and this is probably my little observation as someone who looks at investigation reports that are prepared internally a lot, I think something is lost if an investigator does not really consciously put on their judge's wig when they're writing their report to really think about why they're making the decisions that they are. It's very easy to get overwhelmed by how much information you've got, by your deadline. I've got to do this report. The report's 30 pages long. I've put all this stuff in and I'm going to make these findings. It's very easy to miss out the critical couple of paragraphs to say, why are you making the findings? Is it because you didn't believe that person X did what he said he did for whatever reason? Is it because there was inconsistent evidence with something else? You actually need to put your reasoning in an investigation report, because, as we said before, you should put it in writing. There should be no fear of putting down why you're proceeding, and I think it's actually quite. I mean, it's fun to make decisions on things and have to exercise that level of thinking about things and then putting it in writing. Report writing. As we've just been discussing, when you are making your factual findings, often there's two types of findings. There's factual findings, what actually occurred, and then there's, I guess it's a similar type of factual finding, but it's findings as to breach. This is where you're looking at the policy you got, as Ed mentioned at the start. You got your policy at the start. You're trying to work out whether there's a breach. Give me, Ed, based on that slide, what a decent investigation report looks like. What are the sections that you would see written down in an investigation report and captured?
Sure, I think it's important to start with the background in terms of when the complaint was raised and the methodology you've used to conduct the investigation, but importantly, set out each individual allegation, set out the various evidence, either supporting or refuting the allegation, and then whether you've found the allegation, to be substantiated or not, and the reasoning there. I think they're the key things.
The last point, that I'll become furious about. Recommendations, if applicable. Do not put recommendations in unless you've been asked to do it, because you will not be thanked for it. We've discussed about the fact that the investigation report is, should have your reasoning. Again, and I'll hit on another point that we've raised before. So often we see huge amounts of effort and huge amounts of stress expended by organisations and individuals in organisations to conduct investigations. They've spoken to everyone. They've looked through everything. They're experts on everything to do with the issue, but they don't manifest all of that work into an investigation report which can be relied upon. That just seems an awful waste from my perspective. It can be difficult to close out investigations. It can involve long nights. It can involve deadlines. The business, whoever that may be pushing, where's the investigation report? Where's the investigation report? It's worth doing it properly, because once it's finished, and you would know this feeling well, Ed, once you print as PDF, you send it to the decision maker, it's done. It is your investigation closed off. All the loose ends that you've shown your workings, and that's where you really get the value out of investigation reports, when all of it's there. If 6 months down the track in industrial proceedings, you have to say, oh, well, we did take these steps. If it's not an investigation report or it's not in writing, it's not worth as much.
Yeah. The other thing that I have found, I'm not sure if you found either, Julian, is sometimes it's not clear whether an allegation has been substantiated or not.
Yes.
And I think it's really important to make it clear whether the finding's been substantiated or not right up front.
Well, it's almost a judicial principle. I mean, that's, speaking of putting a judge's wig on, where judgments get appealed is where the decision is not being clearly communicated, or the wrong test has been applied, or whatever it is. It's important to make it quite clear lest anyone be confused about what you found, and then it's over to the decision maker to take it on. So we've got about 5 minutes. Here are 8 top tips, and I think we've hit most of them, but it's a great way of summarising the subject, Ed. Not everything needs to be investigated. I should say pragmatically, investigations are very resource intensive. They're very expensive on occasions. If you investigate everything, not only will you be burning through lots of resources, but you will also create a culture where everything is investigated. It's very bureaucratic. This is not, you don't need to investigate everything, and it's you need to exercise a degree of judgment in how you investigate and what you investigate. The fundamental rules, Ed, what are they?
Procedural fairness, impartiality, and having a paper trail.
There are no investigations, no good investigations that don't have those 3 things. You might be able to get away with, you shouldn't, but you might be able to get away with something that isn't ridiculously documented down on paper if it's a smaller investigation. Ironically enough, on the impartiality point, so long as you don't take any step which is obviously biased and you don't record any, so long as it has the appearance of being impartial, whether you have personal views or whether the business has personal views about a particular issue, it probably isn't going to matter. But you need to have the perception of impartiality at least. Number 3, be mindful of people's well-being, offer support. We're only doing these investigations so, one way to mitigate legal risk, but also to make employers, officers safe, happy, cohesive, coherent places to work. Don't let your investigation negatively affect people's well-being any more than possible. These are stressful though, aren't they, Ed? And we were speaking about it before. One aspect of the pandemic experience of interviews is that in sensitive matters where a witness might need a break because they become emotional and need to cry, it's incredibly difficult when you're on a web screen watching someone cry because they're just being so overwhelmed by the experience. These things take a toll on people. You need to have that in mind in the way that you undertake them and how you conduct yourself.
Yeah, so obviously offer EAP.
Yep.
A contact person in the business, maybe an HR person, and also the commencement of any interview. Just let the participants know they need to have a break at any point. Please let me know. I'm happy.
You're going to get more out of the witness if they warm to you and you build some kind of rapport with them than if they think you're a hard-boiled detective coming in to try and nail them. Consider the views, expectation of the people involved, internal perceptions. We've spoken about that. Consider how the process may be reviewed outside the organisation. I won't labour that point, but I can tell you it is front of mind for many of our clients in how investigations and why investigations should run. Be proactive, stay in touch with participants, keep them updated, and don't be afraid to get on the email, keeping a paper trail. Don't be afraid to get on the email, keeping people updated of how things are going. It will look better in the long run if you're proactive and take those steps. Acting reasonably is probably something that can be tattooed on the head of every HR and employment lawyer in Australia. That's obvious. And from our perspective, this is really hard, some of this stuff. It really is hard, and often, and I know personally, and you do too, as even someone as ridiculously experienced in investigations as you, Ed. Sometimes you need to bounce this kind of stuff off someone. These are judgment calls. Get some advice.
Yeah.
Segue, how can we help? So get advice from us. Don't be afraid to give us a call. We can do a lot for you. We are experts in this space. But more than just that, Ed, we're conducting some workplace investigations training. You'll see on the screen there, the first listing for that is on 30th and 31st of March 2022. Visit our website to have a look at that. We'll also be conducting some advanced investigations training later on in the year. I'm looking forward to the next webcast in the series, which is on sexual harassment changes and fascinating development in the law. It's been fantastic, Ed. I've enjoyed myself immensely. Thank you all for attending, and be safe and well.